Citizens of the gallery, television tells you the trial is where the truth comes out, but experienced litigators know something different. By the time the jury enters the courtroom, the most important testimony may have already been given in a conference room, under oath, months earlier. Today we examine one of the most powerful tools in civil litigation, the deposition.
When most people imagine a lawsuit, they picture a courtroom. A witness walks to the stand, raises a hand, swears an oath, then answers questions before a judge and jury. That certainly happens. But what many people do not realize is that some of the most important testimony in an entire lawsuit takes place long before trial. There is no jury, usually no judge, sometimes not even a courtroom. Instead, attorneys gather around a conference table. A court reporter sits nearby. The witness takes an oath, and every answer becomes part of the official record. This process is called a deposition. For many lawsuits, the deposition becomes one of the most influential events in the entire case. It can expose weaknesses, clarify facts, preserve testimony, encourage settlement, or dramatically change the direction of litigation before trial ever begins. A deposition is sworn testimony taken outside the courtroom during the discovery phase of litigation. The witness answers questions under oath. Every question and every answer is recorded by a certified court reporter. Many depositions are also video recorded. Although depositions usually occur in an attorney's office or conference room, they carry the same obligation to tell the truth as testimony given in court. The witness is not simply having a conversation. The witness is giving evidence. One of the central goals of modern litigation is to eliminate unnecessary surprise. Imagine if neither side knew what witnesses were going to say until the trial began. Cases would become chaotic. Unexpected testimony would delay proceedings. Important evidence might never be properly investigated. Depositions solve that problem. They allow each side to understand the evidence before trial. Lawyers use depositions to discover facts, identify disputed issues, evaluate credibility, preserve testimony, locate additional witnesses, authenticate documents, and assess the overall strength of a case. In many lawsuits, the deposition becomes the moment when both sides finally understand what the evidence really looks like. Many people believe only the parties to a lawsuit give depositions. That is incorrect. Anyone with relevant knowledge may potentially be deposed. Examples include plaintiffs, defendants, eyewitnesses, police officers, physicians, engineers, accountants, business representatives, investigators, expert witnesses, and other individuals possessing relevant information. Being asked to give a deposition means someone simply possesses important information and does not mean someone is accused of wrongdoing. One of the biggest misconceptions is believing depositions are informal meetings. They are not. Before questioning begins, the witness takes an oath to testify truthfully. That oath carries legal consequences. Knowingly giving false testimony may expose a witness to allegations of perjury or severely damage credibility. Every answer becomes part of the official record. Every answer matters. Unlike courtroom examinations, depositions often move at a slower pace. Attorneys may ask detailed questions about events that occurred months or even years earlier. Sometimes they revisit the same topic repeatedly. To the witness, that can seem repetitive. There is a reason. Lawyers are not simply collecting information. They are evaluating consistency, memory, credibility, precision, and completeness. Small inconsistencies do not automatically mean someone is lying. Human memory naturally fades over time. But significant inconsistencies may later become important during trial. Television portrays depositions as non-stop arguments between lawyers. Real life is usually much different. Attorneys do make objections. However, in many jurisdictions, most objections are simply noted for the record while the witness continues answering. Unlike trial, depositions generally allow broader questioning because discovery is intended to gather information. There are exceptions. For example, attorneys may instruct a witness not to answer in limited circumstances involving privileges or court orders. But generally speaking, questioning continues. Another common misconception is that depositions have no limits. That is not true. Questions must generally be relevant to the litigation or reasonably calculated to lead to discoverable information under the applicable procedural rules. Attorneys cannot simply conduct unlimited fishing expeditions into every aspect of a person's life. Courts may issue protective orders if questioning becomes abusive, oppressive, or seeks information outside appropriate legal boundaries. Discovery is broad, but does have limits. Experienced attorneys spend considerable time preparing witnesses for depositions. Preparation is not about inventing answers. It is about helping witnesses understand the process. Good preparation reminds witnesses to listen carefully, answer only the question asked, avoid speculation, avoid guessing, correct mistakes when necessary, and speak truthfully. Many witnesses become nervous simply because they have never testified under oath before. Preparation helps reduce confusion, not manufacture testimony. Many people assume depositions disappear once trial begins. In reality, deposition testimony may play an important role later. Depending upon the applicable procedural and evidentiary rules, deposition testimony may be used to challenge inconsistent testimony, to preserve testimony from unavailable witnesses, or for other purposes authorized by law. This is one reason attorneys pay such close attention to every answer. What is said during a deposition may return months later in open court. One of the least understood aspects of litigation is how often depositions change settlement discussions. Before depositions, each side usually believes its version of events. After depositions, everyone has a clearer picture of the evidence, the witnesses, the credibility, and the risks of trial. Sometimes a party discovers their case is stronger than expected, sometimes weaker. Sometimes both sides realize continued litigation no longer makes economic sense. Many lawsuits settle shortly after significant depositions because uncertainty has been reduced. Common misunderstandings. It's just a conversation. No, it is sworn testimony. I can explain it differently later. You may clarify testimony, but significant changes may be used to challenge credibility. If I don't remember something, I should guess. No, if you genuinely do not know or do not remember, truthful answers are far better than speculation. The lawyers already know everything. Often they do not. One answer during a deposition may completely change the direction of a case. Depositions are governed primarily by procedural rules. In federal civil litigation, the primary authority is Rule 30 of the Federal Rules of Civil Procedure, with related rules addressing document production, protective orders, and the later use of deposition testimony. State courts have their own procedural rules, many of which are similar but not identical. The details may vary. The overall purpose remains the same: to ensure that both sides have a fair opportunity to discover the facts before trial. Depositions reflect one of the defining characteristics of the American legal system. Modern litigation is designed to minimize surprise and maximize informed decision-making. The law recognizes that justice is more likely when both sides understand the evidence before trial rather than being ambushed in front of a jury. Depositions promote transparency. They preserve testimony. They expose weaknesses. They clarify disputes, and they often encourage fair resolution before trial becomes necessary. When people think about testimony, they usually picture the witness stand. But experienced litigators know that some of the most important testimony happens long before the jury ever enters the courtroom. A deposition is not a rehearsal. It is not an informal interview. It is sworn testimony with real legal consequences. Every answer becomes part of the record. Every answer may influence strategy. Every answer may affect settlement. And every answer may someday be read back in court. Because in litigation, the case often begins to reveal itself long before anyone says, "All rise."
If you like this content, then kindly hit like, subscribe, and share. Caesar commands it.